For today's story, we are going to do a deep dive on a legal question that the Supreme Court recently had the opportunity to resolve, but chose not to for whatever reason. The question of attorney-client privilege. So we all understand the concept that communications between an attorney and a client are confidential. They are confidential to the extent that they are in the nature of attorney-client, right? If you are actually talking to your attorney for the purpose of being an attorney, right? So that is the nature of the thing. Well, there's a bit of a complication. What if the lawyer, in addition to giving legal advice, is doing other things that are not in the nature of being a lawyer? What if they are doing other things or providing other kinds of advice? The rules of ethics, incidentally, explicitly allow a lawyer to give non-legally related advice as well. They obviously don't have to. It's not their job. It's not why you hired them. But there's nothing precluding them to. So you go to a lawyer and say, can I do this? The lawyer can say, yes, and also it's a bad idea. You shouldn't do it anyway. So they can say that. They obviously don't have to. So what if you have these sort of mixed communications? What if you have a lawyer and you're asking them both legal and non-lawyer related questions? How do you deal with the attorney-client privilege in that situation? To what extent does the attorney-client privilege extend? And this is a question that the court has not resolved, and we're going to cover a little bit about the state of the law on this question. There is currently 3 dominant positions among the federal courts that have considered this question. Of course, states are all over the map on this as a matter of their own state law, but we're concerned about this as a matter of federal law, right? How do we deal with the attorney-client privilege as a matter of the federal constitutional guarantee, the right to counsel? How do you deal with that? So the federal courts looking at this have taken one of 3 positions so far. Either they are not privileged if they contain both legal and non-legal advice. So how about no privilege at all? They are privileged if the legal advice is a substantial purpose of the communication, to which that would basically mean there is at least a real legal purpose to the conversation, right? Not just a manufactured one, but as long as there's some actual legal discussion that's going on. So that would be position 2. Or position 3, it has to be the dominant purpose of the conversation, which seems to be the test that seems to be sort of the major test at this point, but obviously there's a split. So no privilege at all, privilege if it's at least a real purpose of the conversation, or only privilege if it's the dominant purpose of the conversation. So which of these 3 positions, or some other position, should we resolve? The Seventh Circuit, for its part, said that dual purpose communication, at least as respecting tax advice, was not privileged because, okay, so you want to get tax advice, you go to an accountant, you go to a tax professional, right? Those are not privileged. Or to the extent they are, it's not attorney-client privilege because it's not attorneys. They're tax professionals. Now, there are, of course, tax lawyers who provide tax legal advice. And any lawyer, of course, can provide tax legal advice to the extent they're competent. But the Seventh Circuit said, okay, if what you're doing is just tax advice, that's not attorney-client. It's not in the nature of being an attorney. They might be an attorney, but what they're doing is tax advice. So no, because you don't get attorney-client from H&R Block, you don't get attorney-client privilege in this context as well. So when the IRS sought to obtain documents from this situation, the lawyer refused. Many of the documents were prepared in connection with the tax returns. The Seventh Circuit, while acknowledging some of the documents might be legal in their nature, they're legally privileged. They said that because of the nature of the thing, they could have hired a non-lawyer, and thus, with respect to this, none of it's privileged. So that was the Seventh Circuit's position. The primary purpose test, also known as a significant purpose test, was established by the D.C. Circuit. Was obtaining legal advice a primary purpose of the communication, meaning a significant purpose? This seems to be more in practice like just a bona fide purpose. So if you are going to a lawyer for a bona fide purpose, as opposed to it being a cover, right? So you could imagine a situation where you're going to a lawyer not really because you need legal advice, but you're going to pretend that you do. And there might be some sort of like stuff that looks like legal advice, but it's not really what's going on, right? What you're really trying to do is have a conversation that's protected and using the privilege as a mechanism to protect it. So we'll get into whether or not it's like bona fide legal advice. Was this really legal advice, or were you just trying to use a cover? But the DC Circuit, basically, the way it's sort of developed, has said, okay, as long as it's a real reason, as long as it really was legal advice, then yes, we'll keep the whole thing confidential. So even though there's business purpose to it, like for example, you might be discussing a merger and acquisition, which obviously has legal aspects, but the lawyer might be giving business advice as well about that. And even though that's true, we'll protect the entire conversation. So that was the DC Circuit's position. The majority approach, which seems to be the dominant approach right now, is also emblematic from the Ninth Circuit, which has adopted this primary purpose test and said that attorney-client privilege conversations are only privileged if it's the dominant principal majority purpose of the conversation. So as long as you're going to a lawyer for legal advice and they, in an ancillary way to that, provide some other advice, then that would be privileged, which does seem to be more like what the rules of ethics seem to contemplate, right? Because you're going to a lawyer principally for legal advice. I mean, that's why you hire a lawyer. The rules of ethics for lawyers allow a lawyer to give advice outside of the legal context. But obviously, the dominant reason you went to them in the first place was because of a lawyer. So this is how we're measuring this. We're looking and seeing if whether it's the dominant purpose. So this, for example, would preclude a business from merely CCing legal counsel on document and they all being privileged, right? Because, okay, look, the lawyer might be part of this chain and they might be doing legal work relevant to it to check, but it's not really the dominant purpose of the communication. So the document doesn't suddenly magically become privileged just because a lawyer is involved. So in the DC Circuit's test, you could have an email chain with a business where the lawyer is part of the chain and maybe the entire document is privileged. If the document hadn't included a lawyer, it wouldn't be privileged. But because the lawyer is actually doing real bona fide work for the business, in terms of legal analysis and clearing it through legal is often a step in much business practice, this would make those documents protected. So the practical upshot of this as the DC Circuit would, if you adopt that test, that makes many, many, many more documents from businesses legally protected. So it makes discovery a lot harder, right? Because it makes a lot more documents secret, or you have to fight about the documents a lot more. So it makes it a lot harder to get internal communications because every business would be incentivized to just always make sure they add legal, right? So the Ninth Circuit in the dominant test said, okay, we're going to avoid that problem and prevent these documents from being secret by narrowing it down and saying, okay, the reason you go to the lawyer is primary legal. So it can't be just a legitimate purpose. It can't be just a bona fide purpose. It has to be the dominant purpose. Otherwise, you're not really hiring them as a lawyer. So that's what the Ninth Circuit and seems to be the dominant opinion. So this all came to a head recently in this case called In Re Grand Jury, which was out in the Ninth Circuit, which asked the Supreme Court to consider this very question. There was oral argument on the case. There was a variety of opinions at the thing, but the question presented was very difficult to answer because of these issues. And during oral arguments, the parties themselves did seem to change positions a lot. So yeah, it did seem that way. When the justices asked questions, it seemed like their positions were moving around. The law firm resisting production of documents said the Ninth Circuit approach would make it too difficult to predict whether communications would be protected. But Justice Sotomayor said such predictions will be difficult no matter what you do. Justice Kagan said it was a big ask to depart from the more widely accepted Ninth Circuit approach. But Justice Gorsuch saying for his part, saying he was struggling. So yeah, when you actually tried to get into it and actually tried to like nail it down, it didn't really work, or at least in this context. So the Supreme Court, perhaps somewhat surprisingly, perhaps not, dismissed the case as improvidently granted. So they digged it, as we say, dismissed as improvidently granted, which is the legal equivalent of the Supreme Court never having heard the case at all. So it's like the Supreme Court never took it up on cert. So it's like the Supreme Court never dealt with it, and therefore the Ninth Circuit decision still stands in the Ninth Circuit, to the conflict, notably, of other circuits. So there is a circuit split on this issue. But the Supreme Court, for whatever reason, decided not to resolve it because, well, when they tried to get into it, it didn't really work. So it turned out to be a bad vehicle for the argument, as we say. So there is now this continuing question as to this issue, and also some potentially divide on state versus federal law on this issue, which makes practitioners, when they give legal advice, they have to think about it on both the federal and state context. Because, of course, states can protect privilege more than the federal law requires. So whether it's protected conversations for state purposes and whether it's protected for federal purposes is distinct and in conflict. So if you have multiple jurisdictional practice, if you practice in multiple different states or nationwide, this is something to think about and how you advise your clients in respect to all that. Thus, that brings us to the end of this deep dive discussion as to the issue of attorney-client privilege, a issue, of course, that is near and dear to my heart as an attorney. We all know that legal advice is protected, but what about if you mix it with other kinds of advice? How do you resolve that problem? And there are a couple different approaches to this, all of which make logical, intuitive sense. So it's not like any of them are logically wrong. They all make sense, and it is just simply a line drawing problem. And to make something privileged obviously protects it from discovery. So you have to be cautious, of course, as you create such privileges because, well, it precludes people from getting access to evidence. And there is this sort of maxim that everyone is entitled to every man's evidence. So privilege stands in the way of that. These privileges are long recognized, but overly expanding them can lead to problems, particularly in a business context where suddenly many communications are going through legal, and it would shield businesses from much legal lawsuits. So businesses would probably like it if you expanded privilege more because it would create greater immunities for them, but create greater problems for civil lawsuits and criminal prosecutions against businesses. So trying to figure out where to draw these lines and how to draw these lines creates some real evidentiary problems, something to think more about. At least for a moment, that brings us to the end of discussion of this case.